in our series of Life After Furlough. I apologise in advance if I have any problems with my IT. Due to the wind, my Wi-Fi has gone down this morning, so I'm busy trying to run it off my phone. So if I freeze, don't worry, one of my colleagues will take over from me. For those that don't know me, I'm Teresa Thomas, and I head the 10-strong employment team at Wilkin Chapman Solicitors, the region's largest and highest rated employment team. Many of you I know tuned into last week's webinar on redundancies during furlough. Many thanks for your great feedback and your requests for topics for future webinars. Now I'm going to start today's webinar with an interactive poll. It is confidential in terms of your answers, so I'd like you to get all involved. So coming up on your screens now is the first poll of the webinar. So that will be launched now, and it asks the question: are the majority of your staff currently A, furloughed, B, working at home, or C, working in the workplace? I can see the votes are flooding in. We'll share those results with you when they stabilise, when you've all voted. So 37% of you have got, or no, it's gone down to 36, and the majority of your staff furloughed, 42% working at home, and only 25% in the workplace. So as you know, today's webinar is focusing on issues around unfurloughing staff and returning them to the workplace. You know, we all know that the key message from the government is that work from home if you can. So it's good that a lot of you have got people working from home. But if you can't have the majority of your employees working from home, we've got the secure guidelines that the government have issued around COVID-19, and they're an attempt to ensure that workplaces and your staff working in those workplaces are as safe as possible during this pandemic. Now, I'm sure many of you have spent time reading the guidelines. They're a little bedtime reading for many of you, I'm sure, but they do impose significant responsibilities on you as an employer. There are, without doubt, a number of grey areas as well within those guidelines, and we're going to pick up on those today. So what today's webinar is about is focusing on practical steps you can take to be minimising the risks to your business, as well as how to deal with employees who refuse to return to the workplace for a variety of reasons. So I'm joined this afternoon by two colleagues from the employment team. I'll introduce them to you. The first is Solicitor Tom Martin. Good afternoon, Tom.
Thanks, Teresa. Afternoon, everyone.
And the second is Partner Oliver Tasker. Oliver spoke last week. Afternoon, Oliver.
Hi, everybody.
Now, I'll be asking Tom and Oliver the sort of burning questions that we've been being asked by employers over the last couple of weeks since Boris Johnson's announcement and the guidance came out. But before I do, I'm going to launch our second poll. So that should be coming up on your screen shortly. So have any of your employees raised concerns with you already about returning to the workplace? Have you had them being in touch saying, oh, you know, I'm sick, I'm shielding, whatever, I don't know what I ought to be doing, I don't want to return to work, I've got childcare issues, for example. Thank you for voting. They're coming in. So we're about 59, 60, or just going up above 60% of you now saying that you've already had employees with those concerns about returning to the workplace. So certainly Tom and Oliver's tips that are coming up will help you deal with all of those queries that are being raised with you. Once I've finished with questioning Tom and Oliver, then it's going to be your opportunity to ask questions. We prefer to do this by you virtually raising your hand. So If you don't know how to do this, look at the bottom of your screen on your if you're on a laptop, the top of your screen if you're on an iPad, and there'll be a participants icon. If you click on that and then look on the right hand side, then you click on to raise your hand under that. It's probably best to save your questions until after Tom and Oliver have finished speaking. I'll let you know when you can raise your hands. You can, if you want to, put any questions in the chat, but we might not manage to get to those. I am going to unmute you so that you can ask your question live. So if you leave your computer, please just put your hand down so we don't see your kitchen without you being there. So I'm going to turn to Tom first. Tom, can you help us with how does an employer actually go about unfurloughing an employee that's been sat at home over the preceding weeks?
Okay, yeah, no problem. So I think the process of unfurling an employee is actually quite a straightforward one, really. It just needs to be that you put that to them in writing, confirming that the changes that were implemented when you put them on furlough, so going down to 80% pay, staying at home, they are no longer applicable and that they will be expected to return to the workplace from a given date. Now, ideally, they'll be given a reasonable period of notice of that change. So something in the region of a week, perhaps, albeit that might not be as easy if you need to get people back sooner than that, but just as much notice really as you can give them, I think. And also, I would say in that letter, it's probably best to say to these employees whether or not you believe that this is going to be a permanent change, i.e. they're coming back now permanently, or whether or not you believe it's just to come back to do a certain piece of work, after which time they may be put back on furlough. Obviously, circumstances change and you can only answer that question to the best of your knowledge, but I think it's worth doing that and just putting them on notice that they may be going back if you think that is an option. In terms of then how you go about selecting who you bring back from furlough, well, that's perhaps a slightly more tricky question to answer. Obviously, that will predominantly be driven by business needs. So what people do you need back in the workplace? What set of skills do you require to do the work that you have on at the minute? And what teams might you need back to implement that? Now, you may need the whole team back, you may need the whole workforce back. Obviously, that will be dependent from business to business, but you might also face the situation where you only need a handful of people to come back from a larger team. So how do you go about choosing who from within that pool, if you like, you bring back? Well, there's a number of factors to consider. I think, first of all, you might look at maybe asking for volunteers. So people who say, I want to come back into the workplace and I'm more than happy to do so. That way you at least get the position whereby you have people in the workplace who want to be there and people who are sat at home who are quite content to be sat at home still. Now, that might not always be viable, and I think people's individual circumstances will have to be taken into account when you're looking at that. Now, I know myself and Oliver are going to touch on people who are shielding, people who have childcare issues and all those sorts of issues later on, so I won't touch on it too much now, but they are relevant considerations when you're looking at who to bring back from furlough and may impact who you do select in the long run. Lastly, I think if you're still left with a pool of people to select from, it's just a case of being able to objectively justify your decision using sort of a reasonable rationale. We would almost select, albeit definitely don't call it this, but using almost like a reverse redundancy scenario, so that you go through some objective criteria, score those staff on those criteria and bring back the best scorers as a result of that exercise. Ultimately, the key is just being able to justify that decision and using reasonable criteria so that you're not discriminating against anyone. So avoid leaving all the part-timers at home and only bringing back people who are full-time, and also things like bringing back all the women because you think they may be able to multitask better than the men, for example. It's just about being reasonable and being able to appropriately justify the decision that you make.
I'm glad that was you as a man saying that about multitasking. So the employer's made the decision, they're unfurloughing the staff. What steps that they need to take to a return to the workplace for those employees to make sure everything is safe and they follow the guidelines?
Well, that's the key word there, Teresa. I think is safe. Health and safety is going to be at the forefront of everyone's mind during the COVID-19 pandemic. And so employers, as I'm sure you are all aware, are under a duty to protect the health and safety of their staff, which involves providing a safe working environment and safe working practices. Now, Teresa mentioned the COVID secure guidelines at the beginning, and they are going to be crucial to ensuring that you are compliant with your health and safety obligations. So if you haven't got them out and had them on your bedside table reading them at night, then I suggest that you do so, because they are going to form a lot of what you do moving forwards. Now, as well as publishing those guidelines, which I won't go through because I'm no health and safety expert and we are time constricted here, the government also put in place 5 key steps to ensure that you are compliant with health and safety, and those form the core of all of the sector-specific guidelines that Teresa mentioned. So I'll run through those with you now briefly. The first one is to make sure that you have in place a COVID-19 risk assessment. Now, what that is just analysing all the risks that COVID-19 presents in your specific workplace and looking at what you can do to eradicate those risks or at least minimise them as far as possible. Now, it's strongly advised that you do that in consultation with your workforce, either through recognised health and safety trade union representatives, recognised elected employee health and safety representatives, or where that's not possible, with the workforce generally. They need to be having a say in what risks they perceive there to be on their return to work and how they would like to see those managed, just as important as it is for them to know exactly what risks you have assessed and what risk preventative measures you are putting in place. Now, once that's done, and I'll come on to the remaining points which detail what the sort of things you're going to be looking at in your risk assessment are, but once that's done, it needs to be put in writing, and it's advised that if you've got more than 50 employees, that risk assessment is published on your website so that it's ready, available for anyone to access so that they can see what you're doing about it. So as I've said, the remaining 4 points of that 5-step plan are really going to form the basis of that risk assessment. So the first one of those is hygiene measures. Now, I thought it was a little bit patronising at first when this all came out and I was being told how to wash my hands properly, but it's crucial moving forwards that appropriate facilities for hand washing and provision of hand sanitizer are looked at quite closely, as well as looking at how your workspace is cleaned, so how regularly it's cleaned and how effectively it's cleaned, with particular focus on areas where people are going to come into contact with the most. So to try and minimise the spread of the virus, because that is ultimately how it's spread. The second point, and it touches on something Teresa said at the beginning, is getting people working from home where you can. The message from the government is still absolutely that where people can work from home, they should be doing. So that risk assessment should be looking, as well as at your workplace, at how we can effectively get people working from home and whether there's anything we can do to maximise the number of people that are working from home. Moving on then to social distancing, which I'm sure all of you are now well familiar with by now, except for the odd rogue person in the supermarket who reaches round you to try and steal the last bag of pasta. It is something that most people are doing quite well at the minute. And the risk assessment will need to look at how you implement that in your workplace. So is it possible to have guides put on the floor where people are likely to be queuing? Do we introduce a one-way system so that there's no bumping into people in the corridors? And can we possibly stagger arrival and departure times to make sure that we've not got a mass of people all entering and leaving the building at the same time? Now, where that's not possible, the 5th and final point in the plan is to minimise the transmission risk. So where you can't get people 2 metres apart from each other, how do you best manage that situation? So that will be things like putting up dividers in between people's desks, having people sit back to back rather than face to face, and also minimizing the number of people that people have to come into contact with on a daily basis. So can you streamline shifts or get people down into as small teams as possible so that they're only dealing with a limited number of people? So those are the types of things that you need to be looking at for your risk assessment. And then once you've done that, you need to implement it. It's no good just having it written down. So you need to manage that as best you can, keep it under review, and don't be afraid to discipline employees who are in breach of your risk assessment criteria. It is a serious issue and it should be treated as such. And I think the key takeaway really is to take your time with it. It's better to get this right and take a longer time in doing that than rushing everyone back to work too soon.
Thanks, Tom. I mean, you talked about disciplinary there if people don't come back. Oliver, can you just cover for everybody, you know, if people have got employees who refuse to come to work because they're saying they feel it's not safe, what sort of claims does that employee potentially have against the employer? How seriously do the employer need to be looking at this?
Yeah, this is potentially a huge area and a big area in terms of health and safety law from the employment law side. So I'll be touching upon the main principles that we need to be looking at. As Tom said, the government's issued guidance in terms of returning to work and outlined the 5 key principles. But just purely following that guidance isn't sufficient to discharge the employer's duty to supply that healthy and safe working environment. So one question that we're being asked a lot, well, is if people actually refuse to return to work due to various scenarios, again, which we'll go through later on, what's my rights as an employer? What can I be doing? Can I dismiss them for refusing to return to work? Can I withhold pay, for example, and say that it's unpaid leave if they're refusing to return to work? Now, the short, very simple answer is yes, you can potentially do that as an employer, but that word there, potentially. So the main headline points with this is if there's no discrimination angle and the public health advice is clear that the employee can reasonably be asked to return to work, then a refusal to do so, as Tom mentioned, will be a refusal to follow a reasonable management instruction, which is potentially a disciplinary issue. But the employer needs to really understand, and this is going to underpin everything, the reason for that individual's refusal, and we'll go through the reasons for that now. So the takeaway message is that, or one of them, is that certain dismissals that relate to health and safety and the raising of those concerns amounts to an automatic unfair dismissal, which doesn't need any qualifying service. So the usual 2-year period of service that an employee needs to have to bring a claim for unfair dismissal doesn't count. It's a day one right. And secondly, any action that's short of dismissal could potentially be a detriment leading to a claim as well. So what area of law are we actually looking at? Now, you might have seen it mentioned in the news. It's under Section 44 and Section 100 of the Employment Rights Act, and they deal with health and safety cases. Now, it's not often an area of law that's raised, and as solicitors, as lawyers, it's actually rare that we're dealing with this area until now. I've only been to the Employment Tribunal once in terms of one of these claims under Section 44 and Section 100, so it really shows that they're not very common until now, when we're in a global pandemic and a health and safety crisis. So what does Section 44 say? So Section 44 is the right of an employee not to be subjected to a detriment for either raising a health and safety concern or taking health and safety action. Section 100 of the Employment Rights Act prohibits a dismissal for those same circumstances. Now, both sections of those sections of the Employment Rights Act list various scenarios covering a potential dismissal or a potential detriment. And the one that we're going to see most likely that's going to be raised is as follows, is subsection D. So we'll go through it piece by piece. So this is where, in circumstances of danger, which the employee reasonably believed to be serious and imminent, and which he couldn't have reasonably be expected to avert, he left or refused to attend work if that danger continued. So we just need to break down each element of that to analyse really what the risk is to you as a business and what potential steps you need to be taking in order to address that. So the first element is circumstances of danger. Now, what case law says on this point is that danger has been interpreted extremely broadly by the Employment Tribunal. So certainly the risk of contracting COVID-19 from an infected colleague, a patient, a client, a customer, or even a child perhaps in the education setting would certainly satisfy that initial concept, so circumstances of danger. Now, the employee doesn't actually have to demonstrate, as part of this claim, that the danger actually existed. The question that the tribunal is going to look at and analyse in these cases is whether the employee reasonably believed that, say, for example, attending work would put them in danger. So not that the danger exists, just that they reasonably believed attending work could put them into danger. So this really undermines the importance of the effective communication with employees that Tom mentioned earlier on about the measures that are being put in place to minimise that risk. So always bear in mind those principles that Tom mentioned that's contained within the government guidance. And again, the employer can't be expected to completely eliminate that risk because that's not reasonable, that's not feasible. So the question is whether the employee has a reasonable belief that they're in serious or imminent danger. So what we also need to take into account, and why it's important to discuss the specific circumstances with the employee, is their own health may play a part. So they may have an underlying health condition that you're unaware of that means that they're more at risk. They may have issues with their immune system, or they may be caring for somebody that's vulnerable or at risk as well, which is something that we'll come on to. So the next part of it is about the serious and imminent part of the danger. And again, this is really interpreted broadly by the Employment Tribunal. So it doesn't matter what the employer thought. What matters is if the employee thinks that that danger is serious and imminent. Now, again, coronavirus is absolutely going to be a serious and imminent risk to health, and it's going to be a serious and imminent risk in workplaces. And the government have acknowledged that in all the regulations that they've made about coronavirus. They've even stated within those regulations, within the laws, that they've been made because of the serious and imminent threat to public health. So employees are going to find it very easy to assert that anything that they raise is a potential serious and imminent danger to them. So this part of the test is potentially going to be easily satisfied. So whether the belief is reasonable, again, is going to fall back on the steps that have been taken about risk assessments and guidance being followed, whether PPE has been put into place as well, and the vulnerability of that individual. So again, I'll reiterate, simply following the government guidance by the letter isn't sufficient. It's all about discussing the circumstances with the employee. And a lot's going to depend at the time that the employee raises any issues. Well, what's the current status of the pandemic at the moment? So the serious and imminent part of the test might be less likely to be met, where hopefully we're working towards the fact that infection rates are reducing, that the number of deaths are dropping and reducing overall. So again, it may not be easy to satisfy under those circumstances. Even if it's not reasonable for the employee to say that the threat's serious and imminent, it's still possible, or there still may be a claim that the disclosure of the risk of their health and safety amounts to a protected disclosure. So this is potentially where whistleblowing may come in. And again, to raise health and safety concerns and make a protected disclosure about that, it doesn't require any period of qualifying service. So again, it's a day one right. And if an individual is dismissed or subjected to a detriment for making that disclosure, again, there's a risk of a claim of unfair dismissal, a detriment, and the compensation is in fact unlimited. So the usual caps for unfair dismissal that we used to don't apply. So practically, what can a business look to do to mitigate those risks? Follow the guidance, number one, certainly. Consult, discuss the situation with employees, representatives, trade unions, again, to reach an agreement about any areas of risks and how to address those. So purely marching down the route of taking disciplinary action if someone's refusing to attend work, even if it may be legitimate, may not get your end goal of getting people back to work. You may simply hit a standoff point where you're not getting employees back to work. You need to be a bit more constructive than that, certainly initially, in order to discuss what the employees' issues are. So again, if you refuse to pay somebody because they do not attend work because of a perceived health and safety risk, again, that's a detriment. So there could be a claim for the loss of that pay and the loss of that salary if you don't have sufficient justification to do so. But as I said at the beginning, really, Parliament didn't have a global pandemic in mind when they were creating the laws on health and safety, so Section 44 and Section 100. And because those provisions are so widely interpreted, it really creates difficult situations both for a business and an employee. So in line with public health advice and discussing the situation with the employee, you need to be addressing any concerns that somebody does have to ultimately get them back to work. And again, like I said, it's not an area of law that we really deal with much of the time, and the case law on any dismissals or detriment, we're not going to get the decisions for 18, 24 months, a long way down the line, when the tribunal again is going to be looking at each case individually on their facts. So my advice would, don't be a test case, and seek advice if you are considering taking disciplinary action, or certainly looking to dismiss anyone for the refusal to attend work on a health and safety ground.
Absolutely, Oliver. I'm a lot older than you, and I think I've only ever done one case on Section 44 in my career. And you know, to help you out, employers, what we're going to do now is turn to some of the different scenarios that are most likely to crop up where people are refusing or asking about coming back to work. So Tom, can you please pick up? You know, if someone's saying, well, I can't come back because I consider I'm vulnerable, or the government have sent me the letter about shielding, what should an employer do in those circumstances?
Yeah, that's fine. I think they're two distinct categories, so I'll deal with each of them individually. Oliver mentioned them in terms of they're the obvious sort of individuals who are going to have possibly the greatest health and safety concerns, and so they may well be people that crop up quite regularly raising these sorts of issues. So turning first to those who are extremely vulnerable or shielding in accordance with the guidance letter that they've received from the NHS. Well, these are individuals who are at their highest risk of contracting the virus, and also at the most risk, if they do contract the virus, of what those effects on them are. So they're people who are, for example, organ transplant patients, they're those with severe respiratory conditions, people who are pregnant and have underlying health conditions, and also people who have had certain cancers. So in the letter that they received from the NHS and in all of the guidance that the government, Public Health England, have produced, these individuals have been very strongly advised to stay at home and not leave their house. So obviously that puts in place an immediate barrier to a return to work. These individuals also are most likely to have a protected characteristic for the purposes of the Equality Act, namely either pregnancy or disability. So that brings discrimination into play, and their right not to be subjected to a detriment because of their disability or pregnancy or anything that arises as a result of either of those things. So again, because that is a day one right for all employees, it's something that we are going to have to tread rather carefully around. So, you know, if you are in a position where you're trying to get someone to return to work, then those are two barriers that are going to be in your way. And as Oliver mentioned, they're touching on Section 44 and Section 100. Because these individuals are at the highest risk of contracting the virus and are the most vulnerable to the effects of the virus, then if they were to bring a Section 44 or Section 100 claim, in my opinion, I think a tribunal is very likely to sympathise with their situation and say that returning to the workplace is likely to put them in serious and imminent danger of contracting the virus. So there are three very real, very serious concerns that I think employers need to be aware of if someone does raise an issue about an extremely vulnerable individual returning to work. And the advice is probably, in most cases, barring very exceptional circumstances, these people should not really be returning to work until they've finished their period of shielding. So what are your options? Well, I mean, I spoke at the beginning about selection for bringing people back to work. Well, it is an option if you still need people to be on furlough, to keep these people on furlough for the duration of the job retention scheme. And where that's not possible, can we explore alternative means of getting them to possibly work from home? Can we tweak their role, tweak their hours a bit to accommodate that? Because that's a win-win. Then we get some work from them and they get to stay at home and follow the guidance. Where neither of those things are feasible, the changes to the SSP regulations, which were recently made, have meant that these extremely vulnerable individuals are now deemed incapable of work for the purposes of statutory sick pay. And so at a minimum, if they're not attending work because they are shielding, they're entitled to either statutory sick pay or company sick pay if you operate that procedure. Might also be worth mentioning the possibility of a potential medical suspension given that they're incapable of work. You know, if they are trying to get back into the workplace, looking at the opposite scenario, and perhaps you don't want to take the risk of them coming back into the workplace, then a medical suspension may be an option that you look to use. But certainly with this category of individuals, it's a case of treading very carefully. It is fraught with risk. Turning then to the vulnerable individuals, the sort of next category down, if you like, in terms of severity, they are still classed as high risk in terms of contracting the virus and the effects of the virus. They are not being advised to stay at home. They are only being advised to maintain strict social distancing. So it is in theory possible for a workplace to maintain strict social distancing and to have someone who is vulnerable in the workplace. But again, it's not without its risks. These individuals are likely, again, to have a protected characteristic, either disability or pregnancy, because it includes the over 70s, those who are pregnant, those with underlying health conditions, and also those who care for people with underlying health conditions. So there's that possibility, and again, it needs a degree of care to be taken when we're looking at these individuals because of that. I would also say that because they are still classed as high risk, there is still a good chance that a tribunal would sympathise with their refusal to come back on that basis, and therefore say that they are also likely to be in serious and imminent danger of contracting the virus if they did come back to work. So again, that leaves you in a similar position, albeit with slightly more flexibility, shall we say. And I think it would come back to what Oliver was saying about really getting to know the circumstances of each individual, because each individual case will turn on its own facts. So we need to fully understand why they don't want to come into work and what the risks are specifically for them before we take any decision. The options are similar in terms of keeping them on furlough and also perhaps tweaking their job role to have them work from home. The other difference here is that they are not entitled to sick pay. They are not deemed incapable of work. And so putting them on sick pay or company sick pay or even a medical suspension, probably not as much of an option. So particularly in the short term, we might want to explore the possibility of maybe asking them if they can use some annual leave. And last resort really is unpaid leave, but that does carry those risks that Oliver was talking about in terms of a detriment in not paying them because of health and safety grounds. So if you are looking to perhaps use that as a last resort, then I would reiterate Oliver's advice to seek legal guidance on that point.
Okay. You did mention there, Tom, about caring also for individuals that are shielding or vulnerable. Oliver, can you help us with those people that say, well, I can't come back to work because I'm caring for my elderly mother or relative who is being told to shield shield?
This one's potentially going to crop up a lot, and
what are the options for the employer there?
yeah, this scenario is going to crop up a lot, where people are saying, can't return to work, I'm caring for somebody that's either shielding or is vulnerable. I mean, the starting point is that even the government guidance on shielding states that if you live with somebody that's shielding, that doesn't mean that you have to shield, as long as you can follow guidance on social distancing. So it's not a bar for them to return to work. I mean, employers are probably or might be skeptical as well that realistically, do they have caring responsibility? So a first step may be actually to ask for evidence of that they are caring for somebody that is either vulnerable or shielding as a first step. But again, tribunals are ultimately going to expect employers to act with sensitivity about genuine concerns and look to at least initially avoid taking any disciplinary action or anything further. So again, from a practical perspective, when we're thinking about, again, the wider picture of health and safety cases and potential claims, it's understanding who they're caring for, but then conducting a risk assessment in consideration with the employee to see, well, in reality, if they did return to work, what is the extent of that danger, and can we do something about averting that? Those steps, those measures then put in place should ensure that that person with care and responsibility can hopefully return. Another area, another question about a potential claim under these circumstances that we're often asked is, well, could that individual that has the care and responsibility raise a claim for discrimination? Now, the person that's shielding, as Tom mentioned, they are likely to have a disability. But the one that has the care and responsibility doesn't. But that doesn't necessarily mean that they can't bring a claim for discrimination, because remember, direct discrimination claims are on the basis that the employee is treated less favourably because of the disability. So they may have a potential claim, but in reality, the risk is going to be pretty minimal. And again, because that carer doesn't have a disability, there's no obligation to look at reasonable adjustments, maybe considering a phased return or a change of hours for that employee to come back. So constructively see if there's a way for them to return to work, even with caring responsibilities, or if they perceive that there's a risk with them coming into the workplace that may then impact that vulnerable or shielding individual. Could you put in place measures for that individual to work from home, for example, so at least they are carrying out work? But the main thing is demonstrate that there's not that serious and imminent danger, which will then cut off any health and safety potential claims, meaning that A, you can say it's reasonable to get back to the workplace, and then B, look to take action if they continually refuse to do so.
Thanks, Oliver. Turning to probably what is the second most common question that we're being asked around this area. What if the employee is saying they cannot come back to work because of issues relating to childcare, with the schools, nurseries still being shut, or only some age children likely to return in June, and therefore physically they haven't actually got the time to work because they're looking after the children. So Tom, could you pick that up for us?
Yeah, absolutely. Like you say, it's one of the common ones that we're being faced with, and I think it's going to persist as long as schools remain closed, at least in part, because it's understandable that people who have children and need to care for them are legitimately not going to be able to necessarily leave them alone to attend the workplace. So it is a potentially contentious area, and I think it comes back to what we've been saying about a number of these issues. First of all, that really we need to understand the circumstances that the individual employee is in, because each case and how we deal with it will turn on its own facts. So what is their position in terms of the children that they are caring for? Are there alternative means of childcare that they are perhaps refusing on the basis that they are maybe concerned to send their child to another family member? Or if they're a key worker, then let's not forget that they have a right to send their children to their children's school for childcare during the day, is that a possible option that they have refused to explore? And also, I think perhaps, you know, the age of the child may be relevant. There's a difference between someone staying at home and looking after a 3-year-old and someone staying at home and looking after a 12-year-old. So it's exploring all those circumstances, first of all, are going to be relevant. In terms of then the options of how you deal with that, well, as we've been saying, working from home, can we tweak their role? Can we adjust their role to perhaps accommodate them working from home? If they have younger children, is that a possibility? If they've got older children, you know, do we need to adjust their hours to reflect that? Where that's not a possibility, again, they'll fall fairly low on the list of people that we bring back initially from furlough. So can we keep them on furlough for a period of time while that scheme is operational? And really, as a last resort, then I think we are again looking at things like using of annual leave or using of unpaid emergency dependence leave or parental leave, because we're in the situation where an employer, if they have a legitimate concern about childcare and they, you know, there is no other real option for them but to stay at home and care for their child, I think an employment tribunal would expect us to deal, like Oliver said, with a degree of sensitivity and a degree of flexibility as to how we approach that scenario. And the circumstances are consistently changing in terms of school opening, and we've got to just keep that under review and monitor that as far as possible. I think dismissals or, you know, disciplinary action, as Oliver said, is going to be fairly tricky in these circumstances, and we just need to be sure that if we do take that action, we have a reasonable justification for doing so. So perhaps where alternative means of childcare have been refused in what we see as an unreasonable manner, and that we act reasonably in dealing with that and the sanction that is imposed. So if that is a consideration, again, we probably sound like a broken record, but obtain legal advice before you do that, because it is quite a tricky situation that you're having to deal with.
Good, thanks, Tom. I'm keen to get to people's questions, but just picking up, Oliver, is there anything extra that the employers need to consider around employees who are pregnant that we need to highlight?
Yeah, so we know that there's additional requirements, duties in relation to new and expectant mothers in terms of carrying out risk assessments and analysing any risks in the workplace. But in terms of coronavirus, the public health guidance has specifically stated that it poses a serious threat to pregnant employees, and that they're particularly vulnerable because of that. So what that means is that extra caution, particular care should be taken to minimise any contact with those that are outside of that person's household. So stick to social distancing measures in the workplace, carry out a risk assessment for the pregnant employee as well. And if it looks like you may have to medically suspend to protect the pregnant employee, then it should absolutely be on full pay. So that's all that I'll touch upon for those.
Okay. Another brand new area to employers, Tom, is that about, can the employer carry out temperature checks on staff? Because this is one of the things that the government are sort of recommending as a way forward. But what obstacles are there in place for the employer if they want to go down that route of the temperature checks on staff when they're coming into work?
Well, I think obviously some people are going to be perhaps hesitant to agree to it. And so when we're looking at it, I think initially it's going to form part of looking at the risk assessment and consultation with staff to say, this is what we are proposing to do. This is the rationale as to why. Obviously temperature is one of the symptoms of coronavirus, and so it can be a good indicator. And, you know, we would not want anyone in the office who potentially has those symptoms. So I think there is a reasonable justification to it. I think if as part of that consultation you have employees consent to agree to subject themselves to temperature checks, then there shouldn't really be any barrier to implementing that. It is obviously going to be more difficult if people raise issues and don't give their consent. Possibly we could look at alternative means of maybe asking employees to take their temperature before they come into work, so they're doing it themselves and it's perhaps not quite as intrusive. But ultimately, it would probably be my view that asking someone for a temperature check on their entrance into work is likely to be a reasonable management instruction on the basis of we're complying with our health and safety obligations that we referred to earlier, and that may be subject to disciplinary action. But again, I mean, it's one that perhaps people need to tread carefully. And there are going to be data protection issues that everyone will be pleased to know I'm not going to go into now in relation to how you handle that data, because it is going to be sensitive personal data, and that might be worth looking into as well, in terms of how that is managed.
Okay, last question to Oliver before we turn to your questions. Another area which is really new to employers is, as if there aren't enough new things, but can the employer insist on the employees wearing PPE if that's something that they haven't traditionally done as part of their role?
Short answer, yes. So guidance has made it clear that if you can't socially distance within the workplace, then the business needs to look at appropriate PPE steps on a number of grounds. And if the employee refuses to comply with those, it's as normal, really. You can subject them to disciplinary action, dismissal action, because ultimately, as an employer, you're doing everything possible to protect against the risks of health and safety and coronavirus. So, short answer for that one, yes.
Thanks, Oliver. If people want to ask a question, if they want to put their hand up, I'll just remind you, if you click on the participants icon and then click to raise your question, if my internet doesn't keep saying it's unstable. I've got a hand up from Donna Edgar. Donna, we'll turn to you if you want to ask your question, please.
Excellent. Thank you, everyone. Really good session. When the track and trace comes in, my concern is if one person in the office gets a message to say that they should self-isolate, does that mean everyone around them then has to self-isolate? And does that then mean that can keep happening over and over when the messages keep coming out?
Oliver, do you want to deal with that question?
Love to. Yeah, there's lots of question marks that still are around the track and trace app, it's fair to say. But if we go on the basis that an employee has received that notification that they've come into contact with anyone, ultimately, again, as a business, you've got an obligation, haven't you, to protect the health and safety of your staff. So first step is that you need to analyse and speak to the individual who may have it to decide, well, have they actually come into contact with anyone, how wide that may be, and then do you need to disclose that with their consent to other colleagues to work out if there's a risk that they may have come into contact with that person and should seek to self-isolate. So a lot would depend on the circumstances, obviously, and it's not going to be an easy task, particularly if you've worked in close proximity with colleagues as well, so the risk is high. You're going to need to discuss it with that individual in detail to see, in reality, have they come into contact with others in the workplace.
Okay, thank you.
Thanks, Donna. I've got a question from John Richmond. John, do you want to ask your question?
Yes, please. Afternoon, everyone. My question is just regarding the vulnerable people category, not the extremely one. I think I'm satisfied there. But do we need to, or would you advise for us to, if we need a vulnerable person, or a vulnerable person wants to work in the office for at least some of the time, should we get there effectively to sign away that they are agreeing to that? We have drafted a risk assessment, which I envisage everybody will sign to say they've read and understood. But specifically for vulnerable people, do we need to strengthen that agreement somehow?
Tom, do you want to pick that up as you covered the vulnerable category?
Yeah, that's fine. I think it's right what you say, in that if you've got someone who wants to come into the workplace, then it is something that you need to look at. Ultimately, the health and safety obligations on you and as an employer are non-delegable. It's not something that you can pass to the employee to take the risk onto themselves. So I don't think there's really anything that we could put together for you to get them to sign beyond what it sounds like you have already done, which is absolutely right, getting them to sign that they understand the risks, and they understand and are happy with what you are doing in relation to those risks. But realistically, there's nothing that beyond that will provide you any additional protection. I think it is just a case of perhaps monitoring that, maybe reviewing with them on a regular basis, that they are happy, and making sure that you are doing everything you can to keep compliant with the guidelines, and making sure that risk assessment is consistently updated and reviewed.
Yeah, okay, great, thanks Tom.
Has anyone else got a question? We did have some more hands up, but they put it down. Oh, I've got one on chat. Claire, she said, could we please tell her if an employee
I'll pick that one up. Yeah.
leave, we need
So I'll pick that question up from Claire. Hopefully, Teresa will be muted. Yeah, it's done. Okay. So can you please tell me, if an employee returns from mat leave and we need to furlough her straight away, can we use the pay figure previous to mat's leave starting, or does it have to be based on either average or March? So short answer to that one again is that any period that was furloughed and the reduced pay with that isn't taken into consideration for the furlough purposes. So the reduced pay as part of the mat leave isn't taken into account.
The pay figure previous to maternity leave starting, or does it have to be based on either average or March figure? Or the government, if people need to be off due to childcare, are we okay to have unpaid leave as an option? Tom, do you want to pick that up?
Yeah, that's fine. So as I said, I think ultimately it is possibly an option that you would have to consider. I mean, outside of the COVID pandemic, if you had an employee who couldn't come into work for reasons of childcare, then the likely scenario, other than using holiday, for example, would be for them to use emergency dependence leave, which is unpaid. They don't have a legal right to have that as paid. And so it is an option. It will likely depend on the circumstances of the case. I don't think we can give a blanket answer that that's always going to be a legitimate response. And I think employers should try to be as flexible as possible where they've got legitimate childcare concern issues. But certainly unpaid emergency dependence leave would be an option in those circumstances that is worthy of having consideration of, depending on what the individual circumstances are.
Thanks, Tom. Celia has asked, how do we treat
I'll pick up the pregnant partner one. Again, it's similar to caring responsibilities and that for those that are vulnerable. So you're going to carry out a separate risk assessment for that partner in the workplace to see actually what is the risk and what's their concern with their partner being pregnant. And realistically, you'll be able to put measures in place in most workplaces in order to protect them, to reduce and mitigate the risk. So it's not to continue to come into the workplace, absolutely not. And again, it's about that consultation with the individual to understand what their concerns are. The next question that we've got, Tom, is probably one for you. Can you reiterate if vulnerable employees or sorry, not extreme, when employees living with a vulnerable partner, if they don't wish to come into work but could, is it safe for the company to say it'll be unpaid, unauthorised absence?
Well, when you're dealing with...
do you want to pick that question up?
So I'll pick up the one about the vulnerable employees. So if you've got someone who is vulnerable, then I think unpaid absence is going to really be a last resort. I think these people are at high risk of contracting the virus and in dealing with the effects of the virus, and they're also likely to have a protected characteristic, i.e. disability or pregnancy. So in dealing with these employees, they're going to perhaps have a relatively strong claim under Section 44 or 100 that Oliver dealt with earlier on, in terms of being subjected to a detriment because of their refusal to return to work on health and safety grounds, and having them unpaid is likely to satisfy them being a detriment. So I think unpaid absence is really going to be a last resort in those circumstances, and it's certainly not something that we would advise is done as a matter of course for any vulnerable employees.
Thanks, Tom. Graham's asked, is it possible to re-furlough someone who's been furloughed but then brought back? The answer to that is yes, as long as they are then furloughed for a period of 3 weeks after that, to ensure that you can make the claim for reimbursement under the job retention scheme. Probably got time for one more question. And that's from Leslie. Tom, if you can pick this one up. If the government message is to work at home, which absolutely it is, if possible at the moment, and staff have been doing so without an issue to date, do we actually have a problem then if we now ask them to come back to work? Tom, if you can just answer that briefly.
Yeah, I think obviously that would technically be in breach of the government guidance, which is still that if people can work from home and have been successfully working from home for a period of time, then they should continue to be working from home. I think you would need a good justification to bring someone back into work. So whether it's that, you know, they haven't been able to do all of their job role, perhaps working from home or something to that effect, but I think it would take something fairly exceptional if they can work from home and can do their job from home effectively. I think the action, as at this point in time, is to follow the government guidance and keep them working from home for as long as that remains the case.
Yeah, absolutely. I'd agree with that. So that brings us to 1:30, which is the hour. So I know that we've got a few more questions. So please, or we'll make contact with you just to touch upon those. Just to finalise those. But really, thanks everybody for attending today's webinar and listening and really taking part as well. We're going to contact you shortly with some follow-up questions for some feedback. We'd be really grateful if you could complete that. And it also gives you an opportunity to suggest topics that you would like us to cover in future webinars as part of this Life After Furlough series. We're actually holding our next webinar on Wednesday the 3rd of June, so pop that in your diary at midday. Now, the government have announced that there's going to be changes to the job retention scheme, and we should have the finer detail about that by the end of May. So that's what we're going to be covering in the next webinar, really to go through those changes from the 1st of August So it'll be hot off the press that we'll be covering those. And again, we'll send out invitations for that so that you can sign up, so that you can register next week. But all that remains to be said is thanks everybody for attending. Enjoy the bank holiday weekend. Thanks to Teresa and Tom as well. And please contact us if you need any further advice or you have any other questions. Thanks everybody.